Um, we are going to discuss again. There's a important topic. So three important topic other than the transfer cases. So we'll discuss about the appeal. We discuss about revision. We discuss about reference, and then fourth, transfer of criminal cases. Remember with this, by and large, we able to cover the different circumstances. We discussed about investigation earlier, police power, then the charge, etc., then the court trial procedures. So all these we have completed. Now we come to the appeal revision references. Now, remember in the under the CRPC or under BNSS in the new law also the same thing is being followed. So the two things which is very frequently used, one is appeal, one is revision. These two powers are there by which a person can go to the superior court against some order of the inferior court. The third process references, it is not that frequently used. And the transfer of criminal cases are also similar circumstances where one court can transfer the case to other court. So that power is vested there with the higher court also, because the higher court can transfer from one court to other court of their subordinate court. So those powers are there. We'll look into those powers today. And so let me start with the appeal. Now, so when we look at the appeal in the BNSS, chapter 31 is talking about appeal. There are a large number of sections which within the appeal chapter. So we started from 413 and it goes till 424. So these are sections when they're talking about the appeal provisions. Now, appeal, remember, appeal can only be filed in cases where the law has specifically permitted that is these specific kinds of order against which appeal can be filed. So, in that sense, the power of appeal, though it is much wider power, but it's a limited power. It's only the limited circumstances we can go file an appeal. So, appeal only the time when it is specified. On contrary, revisions are a little wider power. So, when the appeal does not apply on many circumstances, the revision apply. So, we'll discuss about the revision later. Let me see the appeal provisions. So, and what I said that's specifically made very clear in the first section itself, 413, heading of which said that no appeal to lie unless otherwise provided. So there's a very clear mandate that appeal will only lie when it is specifically provided in the statute. So 413 says, no appeal shall lie from any judgment or order of a criminal court except as provided for by this Sanhita or by any other law for the time being in force. So, appeal will only lie when this Sanhita or other law provide for that appeal. This proviso is there, and the proviso says, provided that the victim shall have a right to prefer an appeal against any order passed by a court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and for such appeal shall lie to the court to which an appeal ordinarily lies against the order of the conviction of such court. So here we find one very significant inclusion. What are these significant inclusions? Here they given the right to the victim. So provided that the victim shall have a right to prefer an appeal against any order passed by the court. Remember, the word victim has been defined in section 2, and accordingly those who fulfill the requirement of victims, they do also have a right to file an appeal. So apart from the public prosecutor or other, the victim can also prefer an appeal against any order passed by the court acquitting the accused or convicting for the lesser offense or imposing inadequate compensation. And such appeal shall lie to the court in which the normal courts we find appeal. We know there are various cases in the earlier where the provision was not explicitly given rights to the victim. And accordingly, we find the cases like this of the Supreme Court, Parvinder Kansal versus State, NC of Delhi, where the Supreme Court says that the appeal seeking enhancement of the sentence at the instance of the victim under Section 372 is not maintainable, because earlier the law did not explicitly give this power to file appeal. Now, under these sections, we have a very specific, explicit power has been given that the appeal can be filed by the victim also. So, this is a very wide power which has been given under these sections. So 413, the first section is about the general provisions related to appeal. So what the 413 has laid down? The first basic principle that appeal will lie only on those circumstances when law explicitly mention that the appeal will lie either under BNSS or under the special law. The second part, it also accrue or give the right to the victim that the appeal can also be filed by the victim to the same court where the normally appeal lies. Now we look at section 414, and 414 says appeal from orders requiring scrutiny or refusal to accept or rejecting surety. So requiring security, basically security, or refusal to accept or rejecting surety for keeping peace or good behavior. Now, remember, now this chapter which we have not discussed in the present series, what we are discussing, they specifically laid down the power of executive magistrate to pass those kinds of order for security or surety, etc., for keeping peace and good behavior. So this section laid down about the power of appeal against those orders. So what are those circumstances? First, any person who has been ordered under section 136 to give security for keeping peace and good behavior, to who is aggrieved by any order, refusing to accept or rejecting a surety under section 140, may file appeal against such order to the Court of Session. Remember, these kinds of order by and large pass by the executive authority many times. There may be some circumstances where the magistrate or magistrate, but basically it's executive magistrate's power. So from there, the appeal will lie to the Court of Session, where a person can file the appeal to the Court of Session. It also says, provided that nothing in this section shall apply to persons, the proceeding against whom are laid before a session judge in accordance with the provision of subsection 2 or subsection 4 of section 141. So, it excludes the power of this section under subsection 2(4) of 141. Now, so these are the initial two sections on appeal. Now we say under 415, appeal from conviction. 1. Any persons convicted on a trial held by High Court in its extraordinarily original criminal jurisdictions. Traditionally, earlier, the High Court has extraordinary power. In fact, for a long time, the Calcutta High Court was exercising original power in criminal cases also. But now, I don't think any High Court exercised this power of conducting trial directly. Yes, as an appellate court, they have an enormous power, but directly trial, I don't think any High Court is conducting now. But even in those cases, if they conduct, the appeal will file to the Supreme Court. Now, when we talk about appeal under this chapter, we need to remember uh, that these are the basic right of appeal. It is other than the constitutional right. So when we look at the Constitution of India, we do find there is a appellate power of the Supreme Court. Sometime even High Court also is mentioned there. So apart from those jurisdictions which are constitutional jurisdictions under the Constitution of India, the BNSS itself laid down this possibility of filing appeal. So first, if the any high court is conducting in the original capacity as the original court conducting trial, then the appeal may lie to the Supreme Court. Two, any persons convicted on a trial held by session judge or additional session judge or on a trial held by any other court in which the sentence of imprisonment for more than 7 years has been passed against him or against any other persons convicted at the same time convicted at the same trial may appeal to the High Court. So, any person who got convicted from the Court of Session, now remember under the new law, we don't have a concept of assistant session judge. So, Court of Session implies either session judge or additional session judge. So, when Court of Session pass order, or anyone convicted 7 years of more by any other court, in both cases, the appeal may lie to the High Court. So, under 415, a person can file appeal against that order to the High Court. Now, here you remember many times when we look at the constitutional provisions for filing appeal, there is a leave required uh, of the higher court. Like for example, we hear the word SLP, special leave petition before the Supreme Court. Now those are not right. Those are the court can give leave to file appeal. Court can allow to file appeal. Now when we're talking about the appeal under these sections, these are right. As a matter of right, a person can file appeal to those higher court under 415. Clause 3 says, save as otherwise provided. In subsection 2, any person A convicted on a trial by magistrate of first class or of second class or sentenced under section 364 or in respect of whom an order has been made or a sentence has been made under section 401 by any magistrate may file an appeal to Court of Session. So, when we look at these provisions, when we're talking about appeal from the magistrate court, the basic rules are that from magistrate court appeal is filed to the Court of Session. So that's what basically the basic principles here. And when we're talking about 364, basically provision which says procedure when magistrate cannot pass sufficiently severe. So when a magistrate is of opinion that after hearing the evidence of the prosecution and the accused is guilty and he ought to receive severe punishment of different kind or more severe, then which such magistrate is empowered to inflict, being a magistrate of the second class, is the opinion that the accused ought to be required to be executed bond under 125, may record an opinion and submit magistrate to the CJM. When more accused persons than one are being tried, CGM will decide. CGM to whom the proceeding are submitted may, if think fit, examine the parties and recall the examination and witnesses who already given evidence and may call for any further evidence and shall pass such judgment, sentence or order as we think fit and in accordance with the law. So here mention what's the reason? Reason being that you will find under section the magistrate who is conducting trial, when a magistrate think that okay he might inflict more punishment than what he is authorized to, or in this case deserve more punishment what he authorized to. then in those cases magistrates can transfer the case to CGM. Our 401 says order to release on probation of good conduct or after admonition. So, in respect of whom an order has been passed and sentence has been made by a magistrate under 401. So, in both cases, appeal will lie to Court of Session. So, 364 and 401. 401 is probation or after releasing after admonition, or 364 where the cases are transferred to from the magistrate court to Court of Session. Now, to the CGM. When it happened? Remember, when you look at the first schedule of the BNSS and then look at the power of the court, the judicial magistrate first class can give punishment up to 3 years imprisonment. But when you look at the first schedule, many are cases which are triable by the judicial magistrate first class, where the punishment is 5 years, 6 years, 7 years, even in some cases. But it is magistrate triable. So, a judicial magistrate first class has power to conduct the trial. But when in a law, when a offence says that it is punishable up to 7 years, it does not mean that the magistrate need to give 7 years. Magistrate may give 2 years, magistrate may give 3 years. So it's a discretion of the magistrate that from 1 day to 7 years, that's the basic rules are there. Now, suppose a case being tried where punishment is more than 3 years, so 5 years, 6 years, 7 years, magistrate triable case. So, a judicial magistrate first class conduct trial, or a second judicial magistrate second class conduct the trial, whether their power again much lesser, 1 year imprisonment. But the magistrate thinks that the case deserve higher punishment than what they have a capability, what they are authorized to. So, what's the option available? The only option available that magistrate can transfer the case to CGM, Chief Judicial Magistrate. Remember, the Chief Judicial Magistrate always has a higher power. So, the Chief Judicial Magistrate can give imprisonment up to 7 years. So, the case can be transferred to CGM and accordingly CGM can pass the order. Now, even in those cases when CGM has passed the order, the appeal will lie to Court of Session. So, whether it's an order passed under 364 or whether task passed by the first class judicial magistrate or second class judicial magistrate or order passed by under section 401, appeal may lie to Court of Session. That's the basic rule. Clause 4 says, when an appeal has been filed against a sentence passed under section 64, 65, 66, 67, 68, 70, 71 of BNS, the appeal shall be disposed of within a period of 6 months from the date of filing such appeal. Now, what are these sections 64, 65, 67 in the Nyaya Sanhita? I think these are all basically sexual offenses. So, in the sexual offenses cases, etc., this provision has been provision has been made that in those cases the 64 is rape. 65 is persons committing offense of rape on a woman under 16 years of age. 66 is persons committing an offense of rape. So, it's all sexual offense, as I said to you. I was just reconfirming. Remember, when we have discussed about the power to investigations, and there we have seen section 193, basically charge sheet provisions where the police can submit the charge sheet, or police, section use the word police report. There also, there is a change was made that in some sexual offenses, and the POXO has been added newly, the police has to submit their charge sheet within 60 days time. So, the new law focus are that particularly at least the sexual offenses, these are timelines are being fixed. So, here also the timeline is fixed that when the appeal is being filed, it shall be disposed of within a period of 6 months from the date of filing of such appeal. The general principle of appeal, which Supreme Court long ago has laid down, Eti Dina Bandhu, a convicted person challenges his convictions in appeal, not only seeks to avoid undergoing the punishment imposed upon him as a result of the conviction, He also wants that the either other evil consequences flowing from the conviction should not visit him, and that the stigma which attach to him because of the conviction should be wiped out. The fact that he is set at liberty and would not have to undergo any further sentence of imprisonment would not debar him of questioning the validity of his conviction. The object of such a challenge to conviction is to avoid the other consequences arising from a convictions, and also to erase stigma resulted from such conviction. So when the court discuss about this appeal, might be a person has been released, period term is over, but he has the right to appeal. He might be wrongly convicted. So higher court may think about whether conviction was just or not. So this is the power of appeal. A person has the right to file an appeal. 416. Now, remember these sections is a general principles that suppose if you are pleading guilty, that means you are accepting the guilt. When you are accepting the guilt, why you will file appeal? So entire process is done on appeal. In fact, even if you just look at the CPC, I think it's section 96 or so, 96 clause 2 or something, I don't exactly remember the sections, in the Code of Civil Procedure, where categorically says that no appeal shall lie against a settlement decree. So when both the parties mutually settle something. So here when someone's plead guilty, why there should be provisions for appeal? So that's what it has made clear. In fact, remember in the Bhartiya Sakshodhiniyam or in evidence law, these are general principles. One of the basic important principles of evidence law is fact admitted need not be proof. So once fact is admitted, you don't require any other proof of it. So admission itself is considered as a substantive piece of evidence. Says people can be convicted on that, and when some voluntarily admitting, no question arises for appeal. So that's what this section says, 416, that no appeal in certain cases when accused plead guilty. So 416 says, notwithstanding anything in section 415, where an accused person has pleaded guilty and has been convicted on such plea, there shall be no appeal if the conviction is by a high court, or if the conviction is by a court of session or magistrate of the first class or second class, except as to the extent of legality of the sentences. So that's the different thing, that you can challenge on the issue of legality, but no appeal lies against something which are basically on the admission when the parties plead guilty, and there's a basic rule. So neither CPC permit nor here we have provisions. So no appeal lies when there is some pleading guilty. Another concepts are no appeal in the petty cases. 417. 417 says, notwithstanding anything contained in 415, there shall be no appeal by a convicted person in any of the following cases, namely A, where a high court passes only a sentence of imprisonment for a term not exceeding 3 months, or of a fine not exceeding 1000 rupees, or of both such imprisonment and fine. B, where a court of session passes only a sentence of imprisonment for a term not exceeding 3 months, or of fine not exceeding 200 rupees, or of both such imprisonment and fine. Where the magistrate of the first class has passes only a sentence of fine not exceeding 100 rupees, then where in a case tried by summarily, a magistrate empowered to act under 283 passes only a sentence of fine not exceeding 200 rupees. So in those cases, no appeal lie because the punishment is very minimal, provided that an appeal may be brought against any such sentence if any other punishment is combined with it, but such sentence shall not be appealable merely on the ground, one, that the person convicted is ordered to furnish security to keep the peace, or that a direction for imprisonment in default of payment of fine is included in the sentence, 3. That more than one sentence of fine is passed in the case if the total amount of fine imposed does not exceed the amount herein before is specified in respect of the case. So, some cases the appeal may be filed, but again not on this ground. So that's what the sections are there. So even in petty offences, etc., where the smaller punishments normally given, in those cases also appeal does not lie. Now the other provisions on appeal. So one of the very important section on appeal is 418, and it says, save as otherwise provided under subsection 2, the state government may, in any case of convictions on a trial held by any court other than a high court, direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy. A, to the court of session if the sentence is passed by the magistrate, and B, to the high court the sentence is passed by any other court. So if the magistrate is passed in the high court, if the session judge or additional session judge, they have passed earlier, there was assistant session judge, then in those cases, high court. 2, if such conviction is in a case which the offense has been investigated by any agency empowered to make investigation into an offense under any central act other than this Sanhita. So investigate into this offense under this under any act or Sanhita, the central government may also direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy. A, to the court of session if the sentence is passed by the magistrate, and B, to the high court if the sentence is passed by any other court. So this is basically in the old law. We find section 377. Clause 3 says, when an appeal has been filed against sentence on the ground of its inadequacy, the court of session, or as the case may be, the high court shall not enhance the sentence except after giving the accused a reasonable opportunity of showing cause against such enhancement, and while showing cause, the accused may plead for his acquittal or for reduction of sentence. So even if the appeal is filed by the state, the appeal will not be heard or sentence will not be, order will not pass without giving opportunity of the accused. And when we give opportunity to the accused may also file a separate applications for either reduction of sentence or acquittal, etc. When an appeal has been filed against the sentence passed under this section, these are all sexual offences, the same principle that it should be disposed of within a period of 6 months from the date of filing of such appeal. So we see in the new law, both Bhartiya Nagarik Sanhita and this BNSS also, uh, there's a attempt to make a speedy trial in respect of the sexual offences. That's what the attempt is. So we have seen in the last time appeal against it was by the state government against sentence. So either inadequacy on the ground, they can file appeal. Now we come to appeal in case of acquittal. When there is acquittal, then what will happen? So clause 1 says, save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5. A, the district magistrate may in any case direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by a magistrate in respect of cognizable and non-bailable offence. From an order of acquittal passed by the magistrate in respect of cognizable and non-bailable offences. B, the state government may in any case direct the public prosecutor to present an appeal to the high court from an original or appellate order of acquittal passed by any court other than the high court, not being an order under clause A or an order of acquittal passed by the court of session in revision. So other than those cases, the appeal can be filed by the state. Clause 3 says, no appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court. Now, this is important. Remember, here is not the right. Here is the when the it says that with the leave of the High Court, that means only the High Court can give permission. So High Court first leave can be obtained, then only appeal can go. Clause 4. If such an order of acquittal is passed in any case instituted upon complaint, and the High Court, on an application made to it by the complainant in this behalf, grant special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. Now, again, if any case is started on complaint, so normally remember in the complaint cases, complaint file under section 223 BNSS. In the old law, it was section 200 CRPC. So in those cases, if there is an acquittal, then also the appeal complainant require leave of court. Clause 5. No application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, where the complainant is a public servant, and 60 days in every other cases computed from the date of that order of acquittal. So that means after acquittal order, 2 month time limits are there, and in case of a public servant involved, it's a 6 month time limit is there. Clause 6. In any case, the application under subsection 4 for the grant of special leave to appeal from an order of acquittal is refused, no appeal from that order of acquittal shall lie under subsection 1 or subsection 2. So, if the special leave is being refused, etc., then no appeal lie. So, there are many cases where court try to interpret these provisions. So in Mathai Matthews versus State of Maharashtra, which was an appeal against acquittal, the court says the power of an appellate court to review evidence in appeal against acquittal is an extensive as its power in appeal against conviction. Before an appeal court can set aside the order of acquittal, it must carefully consider the reasons given by the trial court in support of its order and must give its own reasons to must be some reasonable ground. They must give the reason. Remember, these are all judicial order, and any judicial order has to be reasoned. That's a basic requirement. So it should be only reasoned order. There is another case called Umed Bhai Javed Bhai versus State of Gujarat. Supreme Court says entertainment of the appeal by the High Court against an acquittal will be justified only under special circumstances. So not as a general rule, but special circumstances. Union of India versus Pravat Kumar Behuria, and court says if court below has taken a probable view of acquit accused, fact that another probable view would lead to a conviction is no ground to interfere with the acquittal. So remember, normally for convicting in criminal cases, we require proof beyond reasonable doubt. When require proof beyond reasonable doubt, it much higher standard which law has expect. Accordingly, simply some other perceptions etc. does not make much differences. There is another case called Samsul Haq versus State of Assam. And Supreme Court says judgment of acquittal where two views are possible. Views not be set aside, even if view formed by the appellate court may be a more probable one. Interference with the acquittal can only be justified when it is based on a perverse view. So, the trial court giving conviction on the basis of evidence is one thing, and the appellate court against the acquittal on the ground that both views can be taken. Now, when there is a possibility of both views, it's impliedly that the case has not proved beyond reasonable doubt, and in criminal cases, we require to prove beyond reasonable doubt. And accordingly, if there is a reasonable doubt, then the accused is entitled to get acquittal. So, There is a case where Bashira Begum versus Muhammad Ibrahim appeal against reversal of conviction. So Supreme Court says burden of proving an accused guilty beyond all reasonable doubt lies on the prosecution because the prosecution has to prove the case. If upon analysis of evidence, two views are possible, one which point to the guilt of the accused and the other which is inconsistent with the guilt of the accused, the latter must be preferred. Remember, I says that if two views are possible, that means there is a reasonable doubt exists. And accordingly, in those circumstances, the views which are favorable to the accused should be taken into account, or the views which goes against the accused persons. So, reversal of a judgment and order of convictions and acquittal of the accused should not ordinarily be interfered with unless such reversal acquittal is visited by perversity. So, if there is something wrong, etc., on which this law was exercised, then different thing. Otherwise, you need to follow the rule which is there. 420. Earlier it was section 379. So the heading says appeal against conviction by High Court in certain cases. File appeal to the High Court against convictions. Who can file appeal? Section 420. Court says where the High Court has an appeal, reverse an order of acquittal of an accused person and convicted him and sentenced him to death or to imprisonment for life or imprisonment for a term of 10 years or more, he may appeal to Supreme Court. Remember, accused also should get a right to remedy. It's a basic rights. And accordingly, under the CRPC, we given the right to appeal to the higher court. Someone has availed that appeal and filed to the High Court against acquittal. But now accused is convicted. Will it be fair if we don't give a chance to appeal? Answer is no. Now in those, so here the permission is there where the persons, if the acquittal is converted into convictions by the High Court, then in those cases the person has a right to file appeal to the Supreme Court. 421, previously it was 380 of the IPC, is special right of appeal in certain cases. Notwithstanding anything in this chapter, when more persons than one are convicted in one trial and an appealable judgment or order has been passed in respect of any of such person, all or any of the persons convicted of such trial shall have a right to appeal. Now, very important right. Remember, there are occasions in Indian judicial history where, say, from an order of convictions, there are many people convicted. One file appeal to the Supreme Court, and even the cases like death penalty cases, where against one person Supreme Court says no, it's the rarest of the rare cases and he is entitled to death penalty. Now the other party who file also appeal, so other accused also file separate appeal and that goes to another judge. Now the another judge says no, it's not the rarest of the rare cases. So you'll find many study on death penalty, etc., where people argue that this use of discretionary power is not uniform. Many times it might be subjective. So one person out of many accused being convicted file an appeal, other also has a right to file an appeal. 422, appeal of the Court of Session, how hard? So the process in which the appeal to the Court of Session shall be heard by the Court of Session. And 422 says an appeal to Court of Session, how heard? One, subject to the provisions of subsections 2 an appeal to the Court of Session or Session Judge shall be heard by a Session Judge or by additional Session Judge. Because we know now there is no Assistant Session Judge Court. Provided that an appeal against the conviction on a trial held by a magistrate of second class may be heard and disposed of by CGM. Now there's another provisions where in some cases it may be heard by CGM. Clause 2. An additional session judge or a chief judicial magistrate shall hear only such appeals as the session judge of the division may, by general or special order, make over to him, or as the High Court may, by special order, direct him to hear. So, the process in which these applications shall be disposed of by the court. So, this is a very recent case, Susanto Dev versus Babli Mujumdar. And Supreme Court says the remand to magistrate held impermissible when there was enough materials before appellate court on the basis of which appeal on merit could have been decided one way or other, instead of remanding case to magistrate for deciding it afresh. 423 says petition of appeal, and it says every appeal shall be made in the form of a petition in writing presented by the appellate or his advocate, and every such petition shall, unless the court to which it is presented otherwise direct, be accompanied by a copy of the judgment or order appellate against. So when a person file appeal, it is necessary that against them, whatever the provisions are, that need to be included in the petition itself. So 423, talk about it. 424, procedure when appellate in jail, then what to do? So there are many occasions when appellate in jail, appellate not been released on bail. Now under the new law, very interesting that on many places, this BNSS has put some positive obligation on the jail authority for submitting applications, etc. So you'll find in many places in the new act where the jail authority has to inform, submit application. Remember when we discussing about the bail and the parallel section of 436A, where the under trial prisoners, if they are in custody for half the period or for first time offender, one third of the period, they can, the act has given power that the applications shall be prepared filed by the jail authority. So in the new act, when we look at the new act given the enormous power, many times they have used the word about for the jail authority, that what kind of obligations the jail authority should have in respect of uh, filing application. So same way in 424 says, if the appellant is in jail, he may present his petitions of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellate court. So there is obligations on the jail authority to forward the application of appeal to the appropriate court. So that's the 424. Then there's another provisions are there on appeal 425 to 435. Let me see. 425 says summary dismissal of appeal. Many cases court can dismiss summarily. Uh, so in Dhondiba, Gundu, Pomaje was state of Maharashtra. High Court power of summary dismissal can only be exercised after a perusal of the petition and the copy of the judgment. It must give a reasons why no arguable case is made out on a perusal of those document. Remember, any judicial order uh, has to be reasoned, and when a judicial order has to be reasoned, then you have to justify why you are disposing of, why you are not uh, hearing the appeal, etc. So that's what the court says. 426 says procedure for hearing appeal not dismissed summarily. So when the appeal is not dismissed summarily, then what to do? The appellate court does not dismiss summarily, it shall cause notice to time, place to which the appeal will heard. So notice has to be given to the other party will appear, and then the hearing will continue. So that process are there. 427 power of the appellate court. The most important section in this chapter. What kinds of power the appellate court has? Enormous power. Enormous power. So what are those enormous power? A, in case of appeal from acquittal, reverse such order. So that means he can convict the accused. Or the court can commit for retrial. Court can send back or conduct retrial. Or find him guilty and pass sentence according to law. So all this possible. So order of acquittal, he can be convicted. That it can be sent back for retrial. Court can find him guilty. All this possible. B, in case of appeal from conviction, court can reverse the order. Convictions can be converted into acquittal, or can send back for retrial. So commit for trial, discharge the accused, a retrial order by competent court, or alter the finding, keeping maintaining the ultimate outcome, so sentence, or may, with or without altering the finding, alter the nature and extent of the sentence. In an appeal for, there will be other circumstances. See, appeal for enhancement of sentence. So when an appeal is being filed for enhancement of the sentence, one, reverse the finding and sentence and acquit and discharge the accused that possible. Alter the finding, maintaining the sentence, with or without altering the finding, alter the nature and the nature and extent of the sentence, etc. So all those powers are there. Punishment can be changed, person can be acquittal, person can be convicted. So all those, sending back for retrial. So the appellate court exercise enormous power. Appeal from any other order, alter or reverse such order, make any amendment or any consequential incidental order that may be just or proper, provided that the sentence shall not be enhanced unless the accused has given an opportunity. So it's a basic rule: when you are giving higher punishment, then you must give opportunity of being heard to the accused persons. There is another provision has been added, provided further that the appellate court shall not inflict greater punishment for the offence which in its opinion the accused has committed than might have been inflicted for the offence by the court passing the order or sentence under the appeal. So court should not give higher than that punishment. We have many cases where appellate court has changed the judgment. Uh, for example, let me share you one case with you. It's a Calcutta case, and accordingly, you all must need to know. There's a case called Mir Muhammad Umar versus State of West Bengal. It's a 1999 AIR. It was published. It's 1999 and 2000 in ACC. Minimum Umar versus State of West Bengal. Now, in that case, what happened was that there was a man called Mahesh, and he was purchased some shop, etc., in Kolkata, Zakaria Street area, and he was asked for some protection money, which normally many criminals ask on many circumstances. Mahesh refused. He was abducted by Umar and his gang member in the evening sometime. He was lucky enough and run away. Then again in the late night, he was took shelter in his friend, Mahesh took shelter in his friend house. And in the late night time, around 12 or so, he was dragged from that home, threatened to kill, etc. So that was the last scene together with Umar. That morning, the next early morning, at around 4 o'clock, a little nearby, when a police patrolling car was moving around Central Avenue in Kolkata, they found a dead body. So dead body was of Mahesh. So within short time of the abductions, the dead body was found. So the Umar was arrested. He was tried for both abductions and murder cases. Trial court did not find any evidence for murder charges. So there are direct evidences on abduction. So in the old law, Section 27 Evidence Act, some evidence were there, discovery materials, etc. So direct evidence were available for abduction. So abductions proof, last seen together proof, death threat proof, but there is no direct evidence that he has committed murder. So Umar was acquitted of the charge of murder, but he was convicted for abduction. So court given him 5 years imprisonment. He filed appeal to the High Court. He state also filed appeal to the High Court against acquittal in the murder charges. High Court, when the hearing was conducted, he was in jail for around 3 years. At that time, High Court reduced his sentence to undergone imprisonment. So he was released. Then again, state filed appeal to the Supreme Court. Umar also filed appeal to the Supreme Court. Now, Supreme Court in that case says, if the abduction happened in the late night and within short time the persons died, who could have committed murder? The general presumptions come that only those who abducted has committed murder. So you have all other evidences like last seen together, threat to kill, demand for money, Section 27 evidence, etc. All those indicate that no one else other than Umar has committed murder. Supreme Court changed the view of the trial court and convicted him for murder charges. So there are many occasions when trial court orders are changed by the superior court and they can convict. So in an appeal proceeding, the court has all power. So in this case, state versus Ranga Nagoda, court says it is not necessary that retrial must proceed from the point of time at which error in the trial has been committed. It can even proceed from the earlier stage in the particular case. Court has summarized this principle about the appellate court power in dealing with the appeal in Isaac versus Ronald, etc. There's another case called Arunachalam versus PSR Sitar Ratnam. For the Supreme Court in dealing with an appeal against the acquittal, the court will only interfere to prevent violence, miscarriage of justice. 22. Judgment of subordinate appellate court. The rule containing in the chapter 29 as to the judgment of a criminal court of the original jurisdictions shall apply so far as may be practicable to the judgment in appeal or a court of session or CGM, provided that unless the appellate court otherwise direct, the accused shall not be brought up and required to attend to hear the judgment delivered. Order of the High Court on appeal to be certified to the lower court. So when the High Court, whenever a case is decided on appeal by the High Court under the chapter, it's a certified judgment or order to the court to which finding, sentence or order appellate against was recorded or passed, and if such court is that of the judicial magistrate other than the CGM, the High Court judgment or order shall be sent through the Chief Judicial Magistrate, and if such order is that of executive magistrate, the High Court judgment or order shall be sent through the district magistrate. So from the High Court, that orders are being sent to the lower court, which originally has passed those orders. 430, suspension of sentence pending appeal, release of the appellant on bail. Now these are the common principles where the superior court can suspend the sentences pending appeal. Superior court release the persons on bail. So under 430, that powers are there. So pending any appeal by a convicted person, the appellate court may, for the reasons to be recorded by it in writing, order that the execution of the sentence or order conferment that he be released on bail or on his own bond or bail bond. 431 says arrest of the accused in appeal from acquittal. So the court may also issue a warrant directing that the accused be arrested. So that's possible. Now what may is there? Only in cases court thinks that is a requirement. 432, appellate court may take further evidence or direct to be taken. Now, this is another power under 432. So, earlier we have seen the convictions can be converted into acquittal, acquittal can be converted into convictions. Earlier also seen the case can be sent back for retrial, etc. It can be enhance the punishments, etc. Here now, if the need arises, court may take further evidence also, or court may send back for further evidence. So 432 says in dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, shall record its reasons and may either take such evidence itself or direct it to be taken by magistrate, or when the appellate court is a high court, by the court of session or by the magistrate. When the additional evidence is taken by the court of session or the magistrate, it shall certify such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. The accused and their advocate has a right to represent, etc. So those basic rights are taken care of. So in Pankaj Chaturvedi case, court says the power conferred under this section should under should be exercised with care and caution. Appellate court should not refer to additional evidence if produced before it to fill up the gap by either side, more so to reverse the judgment of the trial court. So general rules are it should be avoided, but yes, it's a power which can be used in extraordinary circumstances. 433, procedure where judgment of the Court of Appeals are equally divided. So what will happen if, say, High Court division bench, one judge thinks one side, other judge thinks other side. So that's it goes to larger bench. So when an appeal under this chapter is heard by a High Court before a bench of judges and they are divided in opinion, to appeal with their opinion shall be laid before the another judge of that court, and that judge, after such hearing as he thinks fit, shall deliver his opinion, and the judgment or order shall be follow the opinion. Provided that if one of the judges constituting the bench or where the appeal is laid before the another judge under this section, that judge so required, the appeal shall be reheard and decided by a larger bench. Finality of the judgment and order of appeal. Judgment and order passed by the appellate court upon appeal shall be final, except in cases provided for section 418, 419. We have seen in cases where acquittals are converted into convictions, then a person has a right to file an appeal. So even those circumstances, there is no appeal of a second appeal arises. Provided that notwithstanding the final disposal of an appeal against convictions, in any case, the appellate court may hear and dispose of on the merit A, an appeal against acquittal under 419 arising out of same case, or an appeal for the enhancement of sentence under section 418. Abatement of the appeal. Every appeal under 418 shall be finally abate on the death of the accused. Remember, if the accused is abated, if they dead, then no question arises there. Every other appeal under this chapter except an appeal from the sentence of fine shall finally abate on the death of the appellate, provided that where the appeal is against the conviction and sentence of the death or of the imprisonment, and the appellant dies during the pendency of the appeal, any of his near relatives may, within 30 days of the death of the appellate, apply to the appellate court for the leave to continue the appeal, and if leave is granted, the appeal shall not abate. So that's the one sections within a 435. Earlier it was 394. So in Gurmal's case, court says the term abatement, the term naming of the meaning of abatement can only be taken in the criminal proceeding as discontinuation of such proceeding, owing to the death of the accused convict pending such proceeding. So uh, term abatement implies that that proceedings is not continuing. Okay, that basically the provisions relating to appeal. Now we come to the second part, reference and revision. 436, reference to the High Court. So the references basically is come from the lower court to the higher court. So where any court is satisfied that a case pending before it involve a question as to validity of any act, ordinance or regulations, it can send to the reference to the higher court. So in those so declared by the High Court or which the court is subordinate by the Supreme Court, the court shall state a case setting out the opinion and the reasons therefore and refer the same for the decision of the High Court. So they can send references. A court of session may, if things fit in any case pending before it to which the provision of subsection 1 apply, subsection 1 do not apply, refer the decisions of the High Court, any questions of law arising to hearing to such court. Any court making the reference to the High Court under subsection 1 or 2 may, pending the decision of the High Court, either commit the accused to jail or release him on bail for appear when called upon. 3437, dispose of the case according to decision of the High Court. So whatever the court will decide, accordingly the case will dispose of. Calling for record to exercise power of revisions. Now this is very important. Revision is always used. Now when revision is used, when the cases where appeal is not applicable. So 438 says the High Court or Court of Session may call for an examine the proceeding record of any proceeding before any inferior court situated within its or its local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of the proceeding of such inferior court, and may, when calling for such record, direct that the execution of any sentence, order suspended, and the accused is in confinement, that he be released on his bond or bail bond pending the examination of his record. So this is a revision power. Within exercise of revision power also they can pass the order for bail. All magistrate, whether executive or judicial, and whether exercise original or appellate jurisdiction, shall be deemed to be inferior court to session court, and session court will be inferior to the High Court. So that's the revision power. There are enormous circumstances when court exercise this revision power. So in Islamuddin versus State, the revisional jurisdiction does not postulate reappreciation of evidence, but that should be appreciated in the light of the limitation of the right of to go to appeal. Revision nature of nature of a revision is not a right, but only a procedural facility available to the parties. So this normally apply in cases when this appeal does not applicable, then people go for revision applications. Mohit versus State of UP. Any order which substantially affect rights of the accused or decide certain rights of the parties is not an interlocutory order. 439, power to order inquiry. So on examining any record under 438 or otherwise, the High Court or the session judge may direct the CGM or by himself or by any of the magistrates subordinate to him to make, and the Chief Judicial Magistrate may himself make or direct any subordinate magistrate to make further inquiry into any complaint which has been dismissed under 226 or 227, or into the cases of any persons accused of an offence who has been discharged, provided no court shall make any directions under this section for inquiry into the case of any person who has been discharged, unless such person has had an opportunity of showing cause why such action should not be made. So remember, it's a basic rule that if the accused person's anything is being evicted, there should be need for opportunity of being heard. 440 session judge power to revision. So earlier it was the High Court power. Now session judge power under 440. So in a case of any proceedings, the record of which has been called for by himself, the sessions may exercise all or any of the power which may be exercised by the High Court under 442. So they can exercise also the same power of revision. 441 for power of the additional session judge. So whatever the power exercised by the session judge, it will be transferred to the additional session judge and he can exercise that power. 442 High Court power to revisions. So in the case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may in its discretion exercise any of the powers conferred on a court of appeal by 427, 430, etc. When the judges composing the court of revisions are equally divided on the opinion, the case shall be disposed of in the manner provided by 433. That means the larger bench or third bench. 443 power of the High Court to withdraw or transfer revision cases. So High Court can exercise those power. Option for the court to hear the parties. So save as otherwise expressly provided by this Sanhita, no party has any right to be heard either personally or by an advocate before any court exercising its power of revision. But the court may, if it thinks fit, when exercising such power, hear any party either personally or by advocate. So it's a not the right, it's a court which they allow. High Court order to be certified to the lower court, the same way the High Court order will go to the lower court. We have seen earlier in appeal. So that's the provisions for we talk about the revision application. So we discussed appeal and the same way revision application. We'll come to the last part of today's lecture, transfer of criminal cases. Now that's again 446 to 452. These are the power when the one case can be transferred from one court to other court. So 446, the power of the superior court to transfer cases and appeal. So whenever it is made to appear to the Supreme Court that an order under this section is expedient for the ends of justice, it may direct that any particular case or appeal be transferred from one High Court to another High Court or from a criminal court subordinate to one High Court to another criminal court of equal or superior jurisdiction subordinate to another High Court. Remember, there are many occasions when there are multiple cases are filed in the different states. So this could be one of the ways in which we can deal with it. Clause 2 says the Supreme Court may act under this section only on the application of the Attorney General of India or of a party interested, and every such application shall be made by motion, which shall, except when the application is made by Attorney General of India or the Advocate General of the state, be supported by affidavit or affirmation. 3. When application for exercise of the power conferred by this section is dismissed, the Supreme Court may, if it is opinion that the application was frivolous or vexatious, order the applicant to pay by way of compensation to any party who has opposed the application such sum as it may consider appropriate in the circumstances of the case. There are few occasions when this power is being exercised. So this is the one of the case where court says that takeover of the prosecution from the transferred states by the transferee state is a complete takeover. The transferee state step into the shoes of the transferred state and the transferee state effectively become the prosecuting state. Transferee state has the right to appoint public prosecutor, special public prosecutor for trial, appellate proceeding and all connected proceeding. That's what happens. So the transferee state will deal with the entire matter. Harita Sunil Parab, apprehension of not getting a fair and impartial inquiry. Such apprehension is required to be reasonable and not based upon conjectures or surmises. So, court talk about the grounds when we can look into it. Swati Nirkhi, apprehension of not getting a fair and impartial inquiry of trial is required to be reasonable and not imaginary. Again, similar kinds of word. Riya Chakravarti, we know this case. So only cases and appeal and not the investigations can be transferred. Now 447 says power of the High Court to transfer cases and appeal. So when the different cases are there within the one High Court, so so whenever it is made appear to the High Court that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or that some question of law of usual difficulty is likely to arise, or that an order on this section is required to be made by provision of the Sanhita, or will tend to general convenience of the parties or witnesses, or for the ends of justice. It may order that any offence be inquired into and tried by any court not qualified under one, but it orders respects competence to inquire into try such cases, that any particular case or appeal or class of cases or appeal be transferred from a criminal court subordinate to its authority to any other such criminal courts of equal or superior jurisdictions, that any particular case be committed for trial to a court of session, or that any particular case will be transferred and tried in before it. So that also High Court can do that. So either they can call before it or they can transfer to other session division. The High Court may act either on the report of the lower court or on the application of a party interested or on its own initiatives. Now, earlier also we have seen the state government power. Now, this is the court power. So, state also has a power. Earlier we have seen where the cases can be transferred, but this section exercised by the court where court can transfer from one place to other place. Power of the session judge to transfer cases and appeal 408. So from one judicial magistrate court to other judicial magistrate court, the session court can transfer. So whenever it is made expedient to session judge that an order under this subsection is expedient for the end of justice, he may order that any particular case be transferred from one criminal court to another criminal court in his session division. So session judge have power to transfer within session divisions. So in Usman Ghani Adam Bhai case, so order of the transfer is not to be passed as a matter of routine or merely because an interested party has expressed some apprehension about proper conduct of trial. Power has to be exercised cautiously and in exceptional situations where it is become necessary to do so to provide credibility to the trial, there has to be a real apprehension that there would be a miscarriage of justice. So court caution, because party many times goes with some interest to asking for transfer or sometimes just to make delay the process. They do this kinds of application. So this may be there must be cogent reason. There must be some justifications why the transfers are there, and then court can exercise this power. 449 withdrawal of cases and appeal by session judge. So the session judge may withdraw any case or appeal from or recall any case or appeal which he has made over to CGM or subordinate to him. At any time before the trial of the case or the hearing of the appeal has commenced, before the additional session judge or session judge may recall any case or appeal before he may made over to additional session judge. So remember, session judge is the head of the session division. So if we transfer a case to one session judge, he can withdraw and then he can assign to other session judge. He might have transferred a case to CGM, he can withdraw and assign to other persons. So that power he exercises. Withdrawal of the cases by judicial magistrate. Now same way, in the old law it was 410. We normally used to file these kinds of applications, say where so a persons can approach to CGM for transfer a case from one judicial magistrate to other judicial magistrate. Many times happens, say suppose one judicial magistrate court is empty from last 1 year. What you do? You can go to CGM under this 450 and ask him to transfer to other judge. So for some reason, the court can pass those kinds of order. 451, making over or withdrawal of cases by executive magistrate. So same way, DM or sub DM may make over because the DM is the supreme authority in the among the districts. He can withdraw from one executive magistrate and transfer to other executive magistrate also same way. Reasons to be recorded. Now these are all judicial order and accordingly it must be reasoned. So a session judge or magistrate making an order under subsection 448 or 449 or 450 or 441 shall record his reasons for making it. Remember, these are judicial order and the judicial order must be reasoned.